Good afternoon, everybody. I have a call-in number for y'all tonight. I have probably about 30 minutes left on my call-in number. If anybody wanted to call in, you can call in. The call-in number is 319-527-6727. Let's see. I was broadcasting live on Facebook. I did a little over an hour on there. I'm gonna start going on Facebook and then back and forth to YouTube and stuff like that. So I'm trying to find a good way to divide my time up between YouTube and Facebook. So let's get back to it. All right, I have a call-in number, so y'all call in if you have any questions. Chat. Okay, y'all call if you have any questions. Hit that. Just call in 319-527-6727. Hit that like button for me too, y'all, if y'all don't mind. Sorry about the camera, y'all. I still haven't gotten another computer yet. Oh boy. If you haven't already, please hit that like button for me. I really appreciate it. Let's get to it. I'm going to put the call-in number in the chat. I have a little over 30 minutes on the air for the call-in number. I just got off YouTube. I'm sorry, y'all. I just got off Facebook. I was talking to some people over there on Facebook. And I was trying to get them. The people who I was talking to on Facebook, they are new. Some of them seem new to to the whole law and the admiralty jurisdiction and stuff like that. I want to go over something with y'all. So this is what I'm gonna do. I'm gonna read y'all the bonds in admiralty jurisdiction. And I want you to compare these bonds to the bonds that you used if you ever went to jail and you bond out of jail. That's what I'm going to do. Because I want y'all to understand, if you haven't already, that the nature of the action is admiralty. It's admiralty jurisdiction, y'all. They filing lawsuits against y'all, man. That's what they're doing. So let me go back here. Where is it? Give me about 30 seconds and I'll have it for you. Where is it? Almost got it. Here it is right here. Okay. I wish I could post this into the chat section, but it's too long. YouTube only lets you post like 200 letters or something like that. Y'all call into the show. So right now, what I'm going to talk to y'all about is these bonds in admiralty. So in admiralty courts, bonds are called securities or cautions and are agreed upon between the parties in one of the four following types of bonds. Now, I got all this information from Clerk's Praxis. Clerk's Praxis has been hailed one of the leading books on the jurisdiction of admiralty and admiralty procedure and stuff like that. So this is what I'm going to do. I'm going to read you these bonds, and I want you to just cross-reference these bonds to the bonds within the statutes of your so-called state, or within the, if you've ever went to jail, you've used one of these types of bonds before. So anyway, the first type of bond, it says it's a bond by sureties. This is called a surety bond, where a bailment company issues a bond, i.e., promise, to the court on behalf of the defendant and becomes surety on the bail. That's one admiralty bond now. I know for a fact I've used that bond before when I went to jail in a criminal case. I've used that bond to get out of jail. The door. Give me a second, y'all. It's not locked. I told you. It's not locked. Oh boy. Sorry about that, y'all. Okay, that's one bond. That's one. I've used one of those bonds before. The second bond is called deposit. This is called a property bond, where real property is pledged as a surety for the bail. A pledge is a transfer, bailment, or deposit of personal property as security for a debt. You can find it in 72 Corpus Juris Secundum, Pledges, Section 3, 1987. Hold on, y'all. Give me 1 second. Just making all that noise. Ooh. School out, y'all. School is out. School is out. Let's see. Okay, that's one type. I mean, that's the second bond. Okay, both of those bonds are in the Alabama Code. You can use both of those bonds to get out of jail in Alabama. The third bond is by oath. This is called a personal recognizance bond, aka signature bond. I've used one of those bonds before to get out of jail. This security is given when a party is too poor to find sureties at the discretion of the court. And then there's one more, a bare promise. This security is unknown. This security is unknown in admiralty courts of the United States. So they don't use that one here. So far, the first three bonds that I've read to y'all, I've used all three of these bonds to get out of jail. That's how you know the nature of the action is admiralty. So if you're watching this video, if you've ever been to jail, have you ever used any one of those types of bonds to get out of jail? Just give me a yes or a no. Because I've used three of them. Hit that like button for me, y'all, if y'all don't mind. I really appreciate it. Now I'm gonna post, if you're in Alabama, I'm gonna post to you where you can find all three of these bonds, at least three of these bonds that I just told y'all about. This is where these bonds are gonna be at, right here. This is the statute where you can find these bonds in Alabama. Those are the statutes right there. Right there. If you read that, that's where you're going to see them at. That's where they're going to be at. Let's get... Now, Alabama has... they have three types of these admiralty bonds. They have one that's a little different. They call it a cash bail. So a cash bail is where cash in the amount equal to or part of the total sum of the bail is paid to the court. So it's like the cash is the security. So it's just like another property bond or something. It seems like it is anyway, but maybe I'm wrong. So that's what they're doing. The nature of the action is admiralty, y'all. This is how you can tell the nature of the action is admiralty. Equity does not have a criminal jurisdiction. There's no criminal jurisdiction in equity. There's only two jurisdictions that have criminal jurisdictions. That is common law and that is admiralty. I've had a judge look me in my face, a so-called judge, look me in my face There's a stenographer, right, a court reporter, right there, standing and sitting in front of him. So he's very careful with what he said, because I wanted to determine the nature of the action, and I asked him, was the what was the nature of the action? He looks me dead in my face and he say, it's not common law jurisdiction. He didn't say nothing else. He just said it's not common law jurisdiction. So this is another way you can tell the nature of the action. Read this right here. I want y'all to see this. Do y'all see that? Admiralty courts are civil law courts. Civil law is codes and statutes. That's what civil law is. This says, this is the Code of Alabama annotated. You open this up, there are going to be nothing but statutes in here. They're construing these statutes. See, these are statutes. I want y'all to see this stuff. See how clear this is. That's a statute. I'm not sure if y'all can see that. That's a statute. These are all statutes. The judiciary does not follow statutory procedure. They don't do that. They simply say what the law is and what the law is not. That's it. So, anytime you are in a so-called court and they are following statutory procedure and enforcing statutes, that is an administrative agency. That is where you are. You're an administrative agency. And they're filing a lawsuit against you for allegedly breaching public policy. That's what they're doing. That's what they're doing, y'all. That's what they're doing. I know y'all probably getting tired of hearing me say this, but that's what they're doing. And they've been doing it for a long time. You'll never know this stuff unless you start reading cases. So if y'all have any questions, I'm here. There's the call-in number, 319-527-6727. Let me see what time it is. I've already been live. I've actually been live since 4 o'clock, but I was on, they're trying to put a lien against you. They can't put a lien against you without a judgment. They're trying to put a lien against you. Once they put a lien against you, then they can seize your property. So they can seize your body and put your ass in jail. That's property. Or they can seize your assets, or so on and so forth, like that. So Yusuf is right. You can't put a lien against anybody without a judgment. You need a judgment first. So that's what they're doing. That's the whole purpose of the lawsuit. But they don't want to call it a lawsuit. Give me 1 second. I'll be right back. Sorry about that, y'all. That's what they're trying to do. That, yeah. Man, look. You know what? I'm gonna see if I can find this case while I'm on the air, because I really want y'all to see this and hear this. This is a case in Alabama where they were talking about how the sovereign people of Alabama, because the legislature, they just thought they could do whatever the hell they want to do, that the sovereign people of Alabama had to put them in check. So I'm going to see if I can find this case for y'all. Let's see. Where is it? Did I save it? No. What? I know I saved. I wonder did it delete it? It probably deleted it. Let's see if. Is it this one? Nah, this one ain't it. I don't think this one is it either. I saved it in here somewhere, but I don't know where I saved it at. Boy, I wish I could find that case. If it ain't in here, I'm gonna have to. It's an old case. That's why y'all need to go and read these old cases. If you want to know what's going on, go read these old cases. They gonna flat out tell you what happened in these old cases. They're not gonna sugarcoat nothing. They gonna tell you exactly how it is in these old cases. I think it was. Okay, I think it's this one right here. It's about 18 pages. I'm not gonna read the whole 18 pages. What I'm gonna do is I'm gonna find out. What they're going into the history of the legislative courts. So somebody filed a petition to get this guy. They filed a mandamus. Let me see. Let's see. Okay, I'm scrolling through it right now, y'all. Give me a second. Okay, I'm almost there, y'all. It's coming back now. I'm almost there. I'm on page 7 right now. It is argued with the ability and the plausible grounds by the counsel for the appellant that the phrase judges of the civil court include only the judges of the courts created by the Constitution. So it certainly cannot be said. Okay, I think it starts right here. If it doesn't, I'm going to read y'all something because I want y'all to know. It says, it is argued with ability and on plausible grounds by counsel for the appellant that the phrase judges of the several courts of this state includes only the judges of the courts created by the Constitution and not judges of courts created by the legislature. So y'all already know that they can create so-called courts. Let me see something. In the present, let me see. It is also provision distinctly made which the people of the district who have the share security. A person by law invests in a judicial power, but whom not judge the court is not permitted. In the case of a court, okay, I'm almost there. This is just power. What is August, Pennsylvania? What authority have we for assertion that judges of the several courts? This article was adopted at the time when many courts and other lines. Protect the judge. Okay, I think this is it right here. Yeah, this is it right here. Okay. Now this, I'm gonna post this case for y'all. This is an old case from Alabama. I posted this on my chat on the community section of the channel. Let me see if I got any calls before I start reading this. Okay, so I have about 18 minutes on the air. If anybody wants to call in to talk, if not, I'm gonna go ahead and read y'all this. I'll go back and check. But this is the case that I'm reading right now. It says, I would say yeah, Johnny. I would say yeah. If hold on, Johnny, let me see something. I'll be able to answer that question for you right now. What county are you in Georgia? What county are you in? What I'm gonna do is I'm gonna look up the nearest law library for you. If you go into Borough County, Borough County. Borough County, Georgia, Clerk of the Supreme Court. Okay, Johnny, is the Superior Court in Borough County? You know what I'm talking about? The Superior Court there. This is Borough Court. I'm trying to see if there's a law library there. There's a law library. Okay, so give me 1 second. Let me see. Let me see if I can find you a law library. Okay, they have one in Cobb County, a law library. I'm not sure how far you are from Cobb County. So if what I'm trying to find the nearest law library. If there's not one in Borough County, then you need to go to the nearest county and go to that law library. If you go in there and you look in those books, they should have an annotated book, just like the one I have in here on my office desk. They should have one in there. But this book, I got this offline. Now, let me see. Which are you trying to find? You want the criminal code for Georgia? Is that it? That's even better if it's in the University of Georgia. You probably need to go there. You probably need to go to a courthouse. Let me see. Georgia. Okay. So you want the criminal code of Georgia? Give me 1 second. You may have to order it. Let's see. Law books from Thomas Rutter by one. Let me see if this is it. I'm gonna see if this is it. Trying to hold on. What is? Let me see. Criminal pre-order, the reference, the art of Georgia criminal and traffic law. It seems that every section of that list is another substantive as well. I wonder how many pages is it. I got a link for you. I'm not sure. Let me see. I'm not really familiar with, rules on the road. I wonder if they got any I'm gonna post this link for you and see. You can try this out. If not, just find your local. If it's not in that county, try another county. I'm sure that there's another county close to you with a law library in it. And you should be able to go in there. Let's see. That's what I do. Hopefully that'll go. Okay. Click that link right there and try that link out, Johnny. Let me see. I think I paid like 80 some dollars for this book. No problem, man. No problem. Let me get back to this. I want to read this to y'all. That's what when I read this to you, you're gonna understand. Okay, I see. I need to go and read old cases now. The reason why you want to go and read old cases is because you want to know what happened, what they did back then that has affected what they're doing today. That's why you need to go and read the old cases. So they're gonna but you'll get it. You'll get it. I'll give you all a little commentary on it. But anyway, it says, we admit broadly the doctrine that the people are supreme in the state, subject to the concessions of power made to the coordinate department of the state. But it does not follow from this admission that they have made the legislature supreme. For the security of the judiciary itself, one of the great coordinate departments, the people, in their constitution, have expressly guarded and restricted the power of the legislature. This department, the legislature, has always claimed to be the people, and it has often invaded the rights and authority of other departments. It once elected the judiciary, but the people took, let me read that to y'all again. I'm going to read this to you again. It once elected the judiciary, but the people took from it that power. It once had unlimited control over the tenure of inferior judicial officers, and the people restricted this power. The people now elect all of the judges, and every man duly qualified and placed in office by the votes of the people is a judge. That's because you're sovereign, by the way. Y'all ain't know that. The people have further restricted the power of the legislature to remove the judges, not only by securing the tenure of their office, but also by prescribing express rules and conditions in respect to removals by the Constitution. In this case, the legislature has legislated so as to remove a judge from office. You can't do that because the sovereign people of Alabama told you that you can't do that. But you think you're sovereign. You think you can do whatever you want to do. You can't do that. That's why you need to go and read old cases. They have abandoned the judicial functions of address and impeachment and conferred on them by the Constitution. You can't do that. You can't do that, man. And have ignored the rule requiring a 2/3 vote of each house and forgotten that the governor must remove the censured incumbent, and have attempted to vacate his office by repealing the law that established his court. Let's see. Go down. Suppose that on the next day after this law had been repealed, another law of the same import had been enacted. Who would have been judge of this new court? It would have been Judge Corbin. His office not expired. He was still a judge, and the new enactment provided the very tribunal in which he was authorized to preside in. The legislature did, at the same session, organize a new court, providing for the election of a judge with the same tenure of office, the same salary, and to be paid in the same way. This is what they did with I think they did this on the federal level because they did it to confuse y'all. So you would think that these legislative courts are actually judicial courts when they're not. I think they did that on purpose, if I'm not mistaken. Let's see, blah, blah, blah. Let's see. I don't want to read all this because this is about 18 pages long. I was already on page 9. Let's see. Give me a second, y'all. Contract. I think that, well, yeah, because they're not really talking about it. But I just wanted to read that to y'all when it was it was talking about the people in the legislature. The people took from them that power because they sovereign. So if you can take power from the legislature, can't you take power from the judiciary? Yes, the fuck you can. You are the supreme judiciary. The people are the supreme judiciary. The people have the final say. The people are the only ones who can tear up that Constitution right now if they want to and write a whole nother one right now if they want to. Public servants cannot do that. The only way that they can change that Constitution is in the manner that the people have prescribed them in the Constitution. The people have already said, okay, if you want to change this Constitution, then this is how you got to do it. You can't do it this way. You're not us. You're not sovereign, so you can't do it this way. This is the way that you have to do it. Let's see. There was another case in here. Can I post? Do I have a link to this? No, I don't. But y'all need to start reading old cases. If you want to know what's going on, you need to go and read old cases. That's the only way you're gonna know what happened. That's why I always read old cases. I go all the way back in time and I just read old cases. Let's see. Let me see if I can find this other case for y'all. I kind of want to do a video on it. I think they're talking about law and equity here. Let me see.
Dad?
No, get back.
I want you to call my sisters.
Get back. I'll be in there in a minute. Go on now. Go on. I'll be in there in a minute.
I want you to call my sisters.
Okay. Here. Hold on. Give me a second, y'all. All right, sorry about that, y'all. Here's another case. If y'all want to, I'm not gonna read it, but if y'all want to read it, here's another case. I'll read. I'm gonna read the first paragraph, and just to tell you what it's about. The defendant in error by Henry V. Chamberlain, her next friend, in April 1830, filed her bill on the equity side of the Circuit Court of Mobile. So this is a court in Mobile County, Alabama, and it was filed on the equity side of court. This is before that they merged all of these courts together. That's the whole purpose of it, that I downloaded this case, because I want people to understand that they merged these courts together. I'm not going to read all of that. I'm going to post it into the chat. I'm going to post the citation into the chat, and y'all can read it if y'all want to. Let's see. I only have 3 more minutes on Blog Talk Radio, so I'm going to end that episode on Blog Talk Radio. And I will.
Thank you for using Blog Talk Radio. Goodbye.
I'm going to focus on YouTube for right now. So you can't call in anymore. It's gone. So do anybody have any questions? I'll probably stay maybe another hour, maybe. And I know I've been gone, so I try to stay. If you haven't already, please hit that like button. I really appreciate it. Really appreciate it. Is there any video that I've posted that y'all are having a problem with understanding? Any video? I'm guessing no. Okay, so let's see. I'm trying to think about what I was talking. I was talking to some guy earlier, and I was trying to see. Okay, I'm gonna talk about this then. Do any of you know? I posted this in the videos on my YouTube channel. 3 types of citizen police encounters. Are y'all familiar with that video? Anybody familiar with that video? Do you have any questions about it? If you have any questions about it, I'm gonna go ahead and answer them right now. So, and I'll provide some commentary on this too. But anyway, long story short, I'm going to be reading y'all this excerpt from my ebook. This is the book that I've typed up that teaches you how to sue the police. This is a revised version. It's edited. There are 3 categories of citizen police encounters. 1 is a consensual police encounter. 2 is a temporary detention. And 3 is a full-scale arrest. So a consensual encounter is basically when a police officer is not required to have probable cause or reasonable suspicion. They're just walking up to you. They don't have probable cause to arrest you, and they don't have reasonable suspicion to detain you. So they're walking up to you and they're asking you questions. Since you're free to ignore them and walk away, they're going to say that the Fourth Amendment doesn't apply, which makes sense. So the second one is a reasonable suspicion. They call it a Terry stop or something like that. It's a reasonable suspicion. So reasonable suspicion is predicated upon specific articulable facts that a crime has been, is being, or is about to be committed. And the third one is a full-scale arrest. They can't arrest you without probable cause. So I know some people, they don't know what probable cause is. If you don't know what probable cause is, I think I posted a video of it. If not, I'll just go ahead and explain it right now. So probable cause is a mixed question of law and fact, meaning the facts of the case. Remember when I told y'all it's all about the facts? The facts of the case will always determine if you have been lawfully arrested. They're going to always determine that. So this is what the court takes into consideration. They're going to take this statute that you allegedly violated, and they're going to apply the factual elements that are needed to justify why this officer is arresting you pursuant to this statute. And once they get all of the facts, then they're going to apply the relevant case law to those set of facts to determine if you have been lawfully or unlawfully arrested. Does that make sense? That's basically how it works. So since not all citizen police encounters are seizures, the Fourth Amendment does not always apply. Encounters where the Fourth Amendment does not apply are called consensual encounters. And these are, what I'm reading to y'all is, this is a case citation that was held. These are case citations. During a consensual encounter, a citizen may either voluntarily comply with the police officer's request or choose to ignore them because the Fourth Amendment's mandate of either reasonable suspicion or probable cause is not required. Since the citizen is free to decline the officer's request or otherwise terminate the encounter. It is also important, just because a police officer approaches you on the street and asks you to answer some questions does not mean you are seized. All of this stuff is true, just to let y'all know. This is why if you want to know when you're unlawfully arrested or unlawfully detained, this is why you need to know this stuff. You're gonna have to read cases so you can know this stuff. Let me see right here. Okay, here it is. However, it can become a seizure when an officer, by means of physical force or show of authority, has in some way restrained the liberty of the citizen. So, the best way I know to put this is, the summary of what I just said. The best way I know to put this is, if a police officer walks up to you and just starts asking you questions, and they don't have reasonable suspicion to detain you or probable cause to arrest you, and you refuse to answer the questions, but they, through some means of physical force or show of authority, exert their, try to exert their authority on you, then that consensual encounter will, based on those facts, be converted into an unlawful detention, so to speak, if that makes sense. Let's see what else I got. I'm so tired of reading, y'all. I have no idea. I used to read so many. When I was suing the police, y'all, I read so many cases. I know this stuff off the top of my head. I don't even have to look at it. I know it off the top of my head because they pissed me off so bad, and I was so mad that I just learned this stuff. That I read so many cases. I can't tell y'all how many cases, and for how many hours, days, weeks, and months, and years that I was studying this stuff. Let's see. Perkins, question line topic. All right. Are any of y'all litigating any cases in court right now? Whether it's civil or criminal? Any of y'all have anything like that going on? I talked to one guy. I think it was yesterday. Yeah, you're right. You're right, Johnny. I was talking to some guy day before yesterday, and he said something very interesting to me. He was trying to get his attorney to, if I'm not mistaken, to argue the nature of the action. In other words, he was trying to get his attorney, or he was trying to do it on his own to determine the nature of the action. And so eventually he got a public defender or whatever. And he said he talked to the public defender on the phone, and he said the public defender, whoever he was, said, look, man, a lot of the stuff that the so-called, the sovereign citizen people, a lot of their arguments are true. This is what he told me. A lot of these arguments are true, but he can't go in there and make these arguments, because if he does, he's going to get in trouble with the Bar Association. That's one reason why I don't want to join the Bar Association, because you're not going to tell me what I can and cannot say. You're not going to tell me that. That's one reason why. I am a lawyer. I'm not an attorney. You can't tell me. As a matter of fact, I think I'm 100% correct when I say the right to counsel does not mean the right to an attorney. It just means somebody learned that law for like a lawyer or something like that. What I'm trying to say is it's probably not. It probably never even meant an attorney. It probably meant a lawyer, But they've somehow construed this stuff, and they got a whole monopoly on this whole license to practice law and all this BS or whatever. But he's back to what I was saying. He said a lot of what the sovereign citizens are saying is true, but he can't do it because he'll get in trouble with the Bar Association. And I really believe that. I believe he is 100% correct, because you can't find an attorney that will go in there and, demand to know the nature and cause of the action. I don't even know why these attorneys have "at law" at the end of their names. when it says attorney at law. No, you are not. You are attorney in admiralty. That is what you are. That is what you are. You're not at law because the term at law means common law. So these, anyway, do anybody have any questions in regarding equity? I have, I've still been reading equity and still been studying it. To be honest with you, all this stuff it's pretty easy since everything is based on the facts. So the only thing that you have to do is you have to determine if your facts are equitable. Let me rephrase that. Determine if your facts have merit in a court of equity, and if they do, then you file your bill in equity and you ask for the appropriate remedy of a court of equity. And that's really it. That's all you're doing in your federal lawsuit. That's all you're doing in a motion to dismiss. That's all you're doing in a writ of certiorari, a writ of prohibition, a writ of mandamus. That's all you're doing in an appeal. All of this stuff is the same, y'all. It's all the same way. Everything functions the same way. These people, they're not smarter than y'all, man. People are not smarter than us. They just read, man. That's really it. That's all they do. They just read. Some of these, they're intelligent. They're highly intelligent, if you ask me. I had some cases that was explaining common law jurisdiction some more. Let me see something. These are all equity cases. Let me see still figuring out how to act on behalf of an individual or family member in a civil matter. Thoughts? I actually think you can do it in a court of equity. The whole purpose of equity is this. If there is no remedy for you at law in a court of law, then that's why you would go to a court of equity and you would allege these facts in support of your client. I really think you can do that in a court of equity. There's one, let me log into my account and let me show you what I'm talking about. Hold on. I was shocked to actually even see that in equity. Let's see. Let's see if I can find which page was it. I think it had something to do with custody and children or something like that. Injunctive relief, is it this one? Hold on. Let me see. Family member, is that it? Specific performance. Where did dang it is. Let me see. Hold on, man, because when I saw that information, I sent it to somebody who needed it. So I might have to go and check this mail again. My messages, declaratory judgment. Restrictive covenants. Where's this stuff at, man? I know where it's at. I'm gonna have to find it this way. But give me a second. Give me a second, because I sent this information to somebody who was having some type of difficulties with this in cases court appearance is needed. Is this something like you're trying to represent them or something like that in a civil matter in the capacity as counsel? Is that what you're talking about? Support? Is it something like that, or is it something a little different? Let me go. Where is it at? Oh, it was a habeas corpus, so it's section 7. Okay. Y'all know you can file a habeas corpus in an equity proceeding? I thought that was exclusively applicable to criminal actions. Section 7. I think I'm gonna read that. I think I'm gonna read that to y'all. Says 7-fold. All of it 7-fold. Okay. Where is it at? I'm gonna read that to y'all. So one is the oh, what did he say? Yeah. Okay. Man, honestly, support. You would think that you would be able to do that, being that you can get this whoever it is that wants you to represent them to sign a contract as in other words, they would sign a contract and you would represent them as their counsel, and you would think that would be a binding contract, but these people, they just don't play fair, man. They don't play fair. They don't want people to know. They don't want people to respect you, man. That's why they're not going to let you go up in there and do that. They don't want to give you any type of credence, any type of legitimacy that you even think you know what you're doing, because that's going to cost them money, and it's going to make people probably start listening to you when you start telling people what's going on in these so-called courts. Been searching case law for a while. If you ask me, under the common law, yeah, you could go in and counsel somebody and speak for them in that action at law. Yeah, you could do that. But this is not at law. They're not prosecuting these cases under the jurisdiction of the common law. It's admiralty. That's what they're doing. Let me go back. I want to read y'all something, because I thought this was just amazing, and I'm not going to even lie. So this is a writ of habeas corpus in an equity proceeding. A writ of habeas corpus traditionally has been accepted as the specific instrument to obtain release from unlawful confinement. The purpose of the writ of habeas corpus is to afford relief against actual restraints upon liberty. The writ of habeas corpus does not act upon the prisoner who seeks relief, but upon the person who holds him in what is alleged to be unlawful custody. So do y'all know you can file a writ of habeas corpus in a court of equity to be released because they're holding you because you can't afford to pay child support? You can do that. The reason you can do that is because they can't put you in jail for being indigent and not being able to pay child support. They can't do that. That's unlawful. The only time they can put you in jail is if you are willfully refusing to pay child support. Where is it at? Habeas corpus is not a revisory remedy and cannot be made to answer the purpose of an appeal, certiorari, or writ of error. So let me see. Well, yeah, we already know that. You can do it on a criminal fine too, just to let y'all know. You can file a writ of habeas corpus in a court of equity, uh, because they're saying that you're refusing to pay these so-called criminal fines or something like that. It works the same way. If you're poor and you're indigent, you can't pay these fines. They can't throw you in jail for that. So let's see. This is section 2. Imprisonment for contempt should never be imposed by a judge with failure. I think I posted this on my channel. I probably did. I'm going to get to the part where it's talking about the criminal fines. This is section 3. The custom of imprisoning a convicted defendant for non-payment of fine dates back to the medieval England and has long been practiced in this country. However, inability to pay a criminal fine is not cause for imprisonment. The U.S. Supreme Court stated the matter very well in Williams versus Illinois. We conclude that when the aggregate imprisonment exceeds the maximum period fixed by the statute and results directly from an involuntary non-payment of a fine or court costs, we are confronted with an impermissible discrimination that rests upon the ability to pay, and accordingly, we must vacate the judgment below. I think they call it invidious discrimination or something like that, y'all. Here, the Illinois statute as applied to Williams' works in that's what they talk. That's what they talk about. Works in invidious discrimination solely because he is unable to pay the fine. On its face, the statute extends to all defendants an appropriate equal opportunity for limiting confinement to the statutory maximum simply by satisfying a monetary judgment. In fact, it is an illusory choice for Williams or any indigent who, by definition, is without funds, since only a convicted person with access to funds can avoid the increased imprisonment. The Illinois statute is in operative effect, opposes only indigents to the risk of the Illinois statute in operative effects exposes only indigents to the risk of imprisonment beyond the statutory maximum. By making the maximum confinement contingent upon one's ability to pay, the state has visited different consequences on two categories of persons, since the result is to make incarceration in excess of the statutory maximum applicable only to those with the requisite resources to satisfy the money portion of the judgment. Let me see. Okay. When one is unable to pay a fine and is incarcerated because of the non-payment of the fine, he is entitled to seek release by a complaint for a writ of habeas corpus. That footnote 7. So yeah, you can do that in a court of equity. I didn't even know this stuff. Here's another one. I think this is very interesting. A court having jurisdiction to issue habeas corpus can inquire into the custody of a child and is bound to remand child to proper custodian. The child is the ward of the state, subject to control through its duly constituted agencies. In this state, as in England, the Chancery Court has inherent jurisdiction in all such matters, and now by statute, this jurisdiction is transferred to circuit courts and the powers of chancellors in the various circuit courts. I need to talk about that for a second. I think in Alabama, this is what I think they did. I think the people via the Constitution created circuit courts, and I think the legislature also created circuit courts. So I'm trying to draw the distinction between these two courts, because in the Constitution, the circuit courts they don't have names. But if you want to read an act of legislature, they give these so-called courts names, and they vest these courts with equity jurisdiction and quasi-common law jurisdiction, quasi-equity jurisdiction, via statutes. That's what they do. Um, let's see. The Chancery Court, Circuit Court, and Probate Court may, upon bail, complaint, or habeas corpus, examine into the custody and control of an infant in this state, the paramount consideration being the welfare of such infant. While actions for writ of habeas corpus as to the custody of a child are treated as actions at law, they may be issued by an equity court or family court division of a circuit court. That's some interesting stuff. I'll stop. I mean, if y'all want me to keep reading, I'll read it. But if not, I'm not. There's some other stuff in here about equity. They're talking about. Let me go here. Let's go back up. They talk about equitable defenses, such as equitable estoppel, equitable doctrine of in pari delicato, the clean hands and lashes. There's another one. Let's see what else they're talking about. Specific performance, rescission of contracts, reformation of instruments, avoidable transactions and fraudulent transfers, mortgage foreclosure and equity. Let's see. Easements and rights of way for private use of lock land, landowner, redemption of property from foreclosure or execution sale. I think that might be good. Chapter 18, redemption of property from foreclosure or execution sale. The Court of Equity. Let me see what they're talking about. I haven't had a chance to read this yet, but let me see what they're talking about. Okay, so it's some type of statutory right of redemption or something like that. Let's see. Unlike the equity of redemption, which exists prior to foreclosure and is deemed an interest in the property, in Alabama, the statutory right of redemption arises after foreclosure. Oh, okay, I know what they're talking about. And is a mere personal privilege conferred by statute. It is not property or a property right. Okay. So that's like when your house in foreclosure, when you want to redeem your property back from foreclosure, something like that. You can do it. I know what they're talking about now. I need to read that some more. I think that's pretty good. Let's see. Unjust enrichment. That's a cause of action in equity. Unjust enrichment. Adequate remedies and express contracts polluted. Let me see. Restitution, constructive trust, equitable liens. Writ of prohibition, writ of mandamus, writ of quo warranto, common law, writ of certiorari. I'm gonna do some more of that. I'm gonna read some more of that stuff, man. Okay, I don't want to bore y'all. So before I decide to end this live, I need to know if anybody who's watching have any questions about anything before I decide to end the live. Any questions? What book are you reading from? I'll show it to you. 1 second. Give me a second. Let's see if I can post it. I'll get a copy of the name or something like that. Yeah. That's the book that I'm reading right there. 1 second, y'all. I'll be right back.
I'm hungry.
Okay. So
I'm hungry. fed.
Okay, I'm about to feed you. I'm about to get off right now because you just ain't gonna let me be great. Okay, y'all. I gotta go. I got daddy duty. Anyway, I hope this live helped y'all. If not, let me know. I gotta go on daddy duty, y'all. Sorry, I gotta cut this short. Everybody enjoy your day. I'll try to go live later on this week again, if I can. Yeah. This ain't gonna let me. School is out, man. This ain't gonna let me be great. Can't be great. Oh yeah. I gotta go. Everybody enjoy your day, man. Pray better get this out. Peace, man.